Meets and bounds does not determine disclosure. Requirement facts. A property in northern Arizona had a legal description using meets and bounds. The listing agent did not provide an affidavit of disclosure. Issue. If a property has a legal description using meets and bounds, does that mean an affidavit of disclosure is required? Answer. See discussion. Discussion. A seller is required to provide an affidavit of disclosure in accordance with Arizona Revised Statute, GR 33-422. If I, the seller is selling 5 or fewer parcels, D, the parcels are not subdivided land, and D, the parcels are located in an unincorporated area of the county. Best business practice tip. If an agent is not sure if an affidavit of disclosure is required, call the county to confirm if the property is non-subdivided and in an unincorporated area. Loss of contractor's license probably needs to be disclosed issue. Seller's home was built by a builder who has recently lost his contractor's license due to poor construction. Does seller have to disclose to buyers the fact that the builder of the home has recently lost his license for poor construction? Answer. Probably. A seller has a duty to disclose facts materially affecting the value of the property that are not readily observable and are not known to the buyer. See Hill v. Jones, 151 Ayers 81, 725 P2D 1115, Appar 1986. The fact that the builder of a home lost his license for poor construction probably affects the value of the property. Therefore, disclosure is probably required. Listing broker not required to disclose evidence of drug use in the home issue. The seller lives in New York and is selling an investment home. During a visit to the home, the listing broker finds drug paraphernalia and other evidence of drug use by the former tenant in the home. Does either the seller or the listing broker have to disclose to buyers the existence of drug usage in the home? Answer. Probably not. Under ARS Par 32-2156A, 1. Neither a seller nor a broker in the transaction is required to disclose that the home was the site of a natural death, suicide or homicide or any other crime classified as a felony. Therefore, the felony of prior drug usage in the home generally does not need to be disclosed. If the drug usage created a hazardous condition in the home, e.g., poisonous odors due to manufacturing of methamphetamine, disclosure would be required. Listing agent must disclose that solar panels are leased, not owned facts. The listing agent, based on direction from the seller, advertised the solar panels in the MLS as being owned by the seller. Several days after the seller entered into a contract, the listing agent discovered that the solar panels were not owned by the seller. Rather, they were leased. The solar company had filed bankruptcy, and no lease payments had been made for several years. The listing agent urged the seller to disclose the solar panel lease and related issue to the buyer. The seller has refused to make the suggested disclosure. Issue. Does the listing agent have a duty to disclose the solar panel lease and related issues? Answer. Yes. Discussion. The listing agent's duty of disclosure runs parallel to that of the seller. In other words, the listing agent, like the seller, must disclose all known material facts. Since the solar panel lease and related issues are now known to the listing agent, she must disclose that information to the buyer, even if the seller refuses. Listing agent must disclose seller's pending bankruptcy, regardless of seller's instructions, facts. The seller is having financial problems, and his lender noticed a trustee's sale against the single-family residence. An agent listed the property for sale and ultimately procured a buyer for the property. Escrow is set to close before the trustee's sale occurs. The seller disclosed the pending foreclosure, and the buyer is willing to honor the contract regardless. During the inspection period, the seller advised the listing agent that in a panic, he filed bankruptcy. The seller has instructed the listing agent to keep the bankruptcy a secret, claiming that his fiduciary duty includes a duty of confidentiality. Issue. Is the listing agent prohibited from disclosing the seller's bankruptcy based on the duty of confidentiality? Answer. No. Discussion. An agent's duty to disclose known material facts trumps the duty of confidentiality. See Lombardo versus Albu, 199 Arzur 97, 14p, 3rd, 288, 2000. Additionally, an agent is required by the Commissioner's rule to disclose in writing all known material facts, including that the seller is or may be unable to perform. AAC R4 28 1101 B1. The pending bankruptcy will affect the seller's ability to perform, and therefore must be disclosed to the buyer. Listing agent must disclose a letter from neighbors' counsel as to potential infringement to the buyer facts. 10 days before escrow was scheduled to close, the seller received a letter from a lawyer representing the neighbor. The lawyer's letter claims that several trees that straddle the property line are a nuisance, and that the neighbor is going to remove them at his expense. Issue: should the listing agent disclose to the potential buyer the letter from the neighbor's attorney? Answer: yes. Discussion: real estate licensees are obligated to disclose all known material facts affecting the property. Here, the attorney's letter and the alleged nuisance would constitute material facts which should be disclosed.